Oh, kia ora. My name's Carwyn Jones. He uri ahau no Ngāti Kahununu ki te Wairoa, so my iwi's Ngāti Kahununu, and I am the kaihautu o te whare whakatupu mātauranga at Te Wānanga o Raukau, and I teach into the Māori Laws and Philosophy program there. One of the really important things about the context, I think, is the preceding Declaration of Independence in 1835, He Whakaputanga, which set out where Māori, the rangatira, declared that they exercised collectively the sovereignty or authority here in Aotearoa and nobody else did. Now what we see leading up to Te Tiriti in 1840, already seeing of course by the 1830s, is the arrival of more settlers, and there's a concern both from the missionaries asking the government in the UK to establish some authority here, to have some control over the settler population, and there's also interest from the Māori population as well that the British Crown exercise some form of law regulation over its citizens who are here in Aotearoa. The parties to Te Tiriti are the rangatira on behalf of their communities, and they're entering into an agreement with the British Crown. And so we have Hobson signing on behalf of Queen Victoria. So one of the things that we know about instruments that we call treaties, that they happen between the agreements between two or more sovereign nations. And so just in the language of thinking about the Treaty of Waitangi, we can see there's an indication that it ought to be seen as an agreement between sovereign nations. So the Māori language version is really, I think, the authoritative text, and the Waitangi Tribunal has looked at this and has, although the tribunal is required to take account of the English text as well, the tribunal's also said that more weight ought to be given to the Māori text. I think the strongest reason for that is because almost all the rangatira who signed the te reo text, Te Tiriti. Also, all the explanation which took place in discussion around what these concepts mean and what the meaning of this agreement would be took place in Māori. There's also a principle of international law, where the Latin term is contra proferentum. Where you have more than one language text of a treaty and where there's some ambiguity or discrepancy between them, you take the text, or you give weight to the text that is not from the drafter. The burden is on the party that drafted the treaty to make sure that the other language text is as close or as accurate, and that there's no discrepancy, and that they end up bearing the burden if they're not the same. I think it's quite useful to think about the English text as a draft, and to see that as part of the context that we might use to interpret Te Tiriti, along with all kinds of other parts of contextual information that we have, but it's not a text of equivalent status as the te reo text, Te Tiriti. So when we think about a treaty, I think it's useful to think about it as an exchange, that if we've got two or more parties entering into it, we should expect that each party's looking to get some benefit from entering into this relationship. And so if we look at the first article, that's about the authority that's going to the Crown. And in the Māori text, that's the word that's used as kāwanatanga. And so kāwanatanga is all those things to do with the governor. So we might think of it as government, sort of functions of government. And so that's the authority that the British Crown is getting. The Waitangi Tribunal's been pretty clear that that what was granted there was authority over the British settler population who were here. So the Crown's own citizens who were, or subjects as they referred to at the time, who were here in Aotearoa. Now, the English text, of course, talks about a cession of sovereignty, and the Waitangi Tribunal has been pretty clear that Māori who signed Te Tiriti o Waitangi were not ceding sovereignty. They were granting the authority of the British Crown to exercise government over the British Crown's own subjects who were here in Aotearoa at the time, and from that point on. And so it's a much more limited form of authority than we might think of as being associated with sovereignty today. Article 2 of Te Tiriti is about what's being guaranteed to Māori. And the kind of big idea in Article 2 is tino rangatiratanga. Rangatiratanga is those things to do with the chief or chieftainship, and that tino at the start is an intensifier, so it's all the very special qualities or absolute chieftainship as we might refer to it. And so that's the kind of concept of Māori authority that's being guaranteed to be maintained. And I think those are the two big ideas in terms of setting out these two spheres of authority. The Crown's authority as kāwanatanga, continuing Māori authority as tino rangatiratanga. And tino rangatiratanga, of course, is the absolute qualities, all those dimensions of chieftainship. So it's much more than simply property rights, but it's a political authority that's contained there. And then in the third article too, there's also a guarantee to Māori that they would also have what in the English text is talked about as the rights and privileges of British subjects, but it's essentially a kind of equality provision or citizenship provision that Māori will be able to exercise the same rights as all other New Zealanders. You might hear people talk about the fourth article of the treaty, which was raised in part of the discussion and part of the agreement that took place at Waitangi, and that's a kind of religious freedom clause. Not specifically intended to protect Māori religious or spiritual practices, but broad enough so that it does. So, principles of the treaty, in one sense, are simply the ideas that underpin the agreement in 1840. They've come to have a particular technical legal meaning in law and policy, and because it's been the mechanism by which government has chosen to and has preferred to engage with the treaty, and treaty principles has been the way it's done that, of saying here's how we're going to make good on our obligations, and so it recognises that. So we first see this concept of the principles of the Treaty of Waitangi used in the Treaty of Waitangi Act in 1975, which is the legislation which sets up the Waitangi Tribunal. And the tribunal is required to assess claims based on this concept, the principles of the Treaty of Waitangi. Parliament doesn't define what those principles are, but says the Waitangi Tribunal is required to look at both the English text and the Māori text in determining what those principles are and figuring out how they ought to apply in particular circumstances. And so since 1975, we've seen the Waitangi Tribunal engaging in that work of determining what treaty principles are, seeing how they apply, and we've also seen this concept, the principles of the treaty, used in other pieces of legislation. And so we've also seen the High Court, Court of Appeal, Supreme Court making statements around what the principles of the treaty are and how they apply in those contexts. So when we have treaty principles provisions in legislation, then that does provide a hook or a mechanism for the court to hold government accountable and often to make decisions which are consistent with treaty principles. The Waitangi Tribunal's jurisdiction is a little bit different in that its whole jurisdiction is based on the principles of the treaty, and so any Māori is able to bring a claim to the tribunal alleging that the Crown has breached those treaty principles and that as a consequence they've suffered some prejudicial effect. The tribunal, for the most part, doesn't make binding legal orders. It makes recommendations to government about either how to address the prejudice that's already occurred or to prevent similar prejudice occurring in the future. Now, some of the key ideas that we've seen both from the courts and the tribunal are principles like partnership, and so that's really reflecting this idea that if you've got Māori authority and the authority of kāwanatanga of the Crown, then you've effectively got a kind of sharing of public authority, you've got some partnership there. So a principle of partnership, and so within that there are ideas that the treaty partners should relate to each other, reasonably and with utmost good faith, those kinds of ideas. We've got a principle of active protection, and that's sort of reflecting really the positive guarantees that are set out by the Crown. The Crown says that will guarantee to Māori that your tino rangatiratanga will be maintained in relation to your taonga, all those things that are highly valued to you. We've got a principle of redress, so that where there have been breaches of treaty principles, there ought to be some remedy for that, some redress provided. But there are also other principles as well, principles of mutual benefit, of equity, of options, so that Māori ought to be able to choose to be able to access kaupapa Māori services or kind of mainstream services, reflecting the rights in Article 2 and Article 3 in that way. We've got nearly 50 years of the Waitangi Tribunal examining particular instances and determining what treaty principles are and how they ought to apply. We've had almost 40 years of the courts engaging with treaty principles in other kinds of contexts. So we've got lots of information, and it's pretty certain and settled. We know actually what partnership means, what are the kinds of things you need to do to demonstrate you're acting reasonably and in good faith. So I suppose the key limitation of the principles from my perspective is that they're all set within the framework of how the Crown currently understands and asserts sovereignty. And so that means that tino rangatiratanga is immediately constrained into that box that's consistent with Crown sovereignty. So it's a kind of compromise in that respect. And I mean, that has been a mechanism which has allowed some gains to be made, I think, because it's this mechanism that allows the Crown to engage with the treaty in a way that doesn't disrupt its own sovereignty. But I think it does provide a limitation. It doesn't allow for the full expression of tino rangatiratanga. A couple of the ways that we've seen the courts using treaty principles to hold government to account or to require government to make decisions again, take into account treaty principles. We've seen the state-owned enterprise case, which has involved ensuring there's a protection for Māori land that might be needed for the settlement of claims. We've seen there's a treaty principles provision in the Conservation Act. The treaty principles provision has been used by iwi groups to ensure that the Crown is taking into account their relationship with that land when they are making decisions about who gets to operate businesses on conservation land. One of the things that would happen initially if the treaty principles are removed or substantially redefined is that it would create a whole lot of uncertainty, because we've had a period of nearly 50 years of the Waitangi Tribunal operating, nearly 40 years of the courts engaging with this and setting precedent based on the definitions and the applications of treaty principles that are built up over that time. Now, if that's removed, that immediately creates uncertainty as to how the courts are going to take account of Te Tiriti and what obligations the government might have. But there's also then a question about how does government deliver on its obligations? How does it serve Māori? How does it address the kinds of inequities in health and in other kinds of contexts as well? And treaty principles provides a mechanism for government to think about how it does that and to think about how it engages with Māori. And so they can provide some useful guidance for government on how it ought to live up to its obligations and how better to provide outcomes for all of its citizens.